Okay, good morning, everyone. We are now streaming live on YouTube. My name is Judge Anyama Farrey, and I will be presiding over your first appearance hearing today before the Clayton County Magistrate Court. Everyone, please raise your right hand so I can go ahead and swear you in. I'm sorry, deputies. Looks like we lost one of the pods. I don't see the male pod on.
Yeah, that's the side. Let me go over and see what's going on.
Okay, you all can put your hands down. Hold on one moment.
Are we ready?
Okay. All right, it looks like everyone's back. Okay, so if I can have everyone go ahead and raise your right hands, please. Let me swear you in. Do you swear and affirm that the statements you'll give before this court and the statements contained within your application for a court-appointed attorney is true and correct? If so, say I do and lower your hands. Okay, thank you. As I mentioned earlier, in case you missed it, my name is Judge Anyama Farrey. I will be presiding over your first appearance hearing this morning before the Clayton County Magistrate Court. Now, I have a few announcements and information to give everyone, so just listen carefully because a lot of this information is going to apply to all of you in your case. We are not here to try your case, so keep that in mind when I call you to come before me. So today is not the day to plead your case. Today is not the day to state whether you are guilty or not guilty. That's not the purpose of today's hearing. You are here before the court so that I can inform you of the charges that have been brought against you, so that I can inform you of certain rights that you have. I will be setting bonds on those offenses for which I am authorized to set bond on. And I am here to schedule what is called a preliminary hearing date if necessary. And I am also here to determine whether or not you will be eligible for a court-appointed attorney to represent you. You have the right to remain silent today and say nothing. But should you give up this right, keep in mind that anything that you state before this court may be used against you if this case goes to trial. As I mentioned earlier, these proceedings are being streamed live on YouTube, so that way the public has access to the court system. So keep that in mind when you come before me. Now, during this and all other proceedings, you do have the following rights. You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to indictment by the grand jury for most felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine any witnesses who are called to testify against you. You have the right to compel the attendance of witnesses in your own behalf by subpoena. You have the right to testify and offer other evidence in your own defense, should you choose to do so. However, should you choose not to do so, there will be no presumption of your guilt raised against you. You'll also have the right to have an attorney represent you. Many of you, if not all of you, completed the court-appointed attorney application form. So when you come before me, I will let you know whether or not you have been approved to have a court-appointed attorney or a public defender represent you. Some of you will be allowed to post what is called an unrestricted bond. The unrestricted bond will be posted in order for you to be released here today. This bond may be in three ways: a cash bond, a commercial bond, or a property bond. So if you decide to use a cash bond, what that means is that you'll pay the full amount of what your bond is to the sheriff's office, plus any mandated fees that the sheriffs require. The sheriff will hold your cash until after the final disposition of your case. And then your cash will be returned to you or the person who posted the cash bond for you. That's the first option. If you're not able to post the entire amount of your bond in cash, then the second option is a commercial bond. If you decide to use a commercial bond, you will have to use a bonding company that is approved by the Clayton County Sheriff's Department. These are private companies who charge different fees to post the bond for you. Bonding companies usually charge up to 15% of the total amount of your bond. as their fee for their services, and the fee that they charge, you do not get it back. I don't work for the bonding company. I don't have any details about the bonding company and their fee schedules. So I don't know how much each bonding company charges. I just know that oftentimes it's up to 15% of whatever bond amount I tell you your bond is. Now, the third option, if you don't use a cash bond and you don't use a commercial bonding company, the third option is that you can post what is called a property bond. So you would need to find someone who owns property and that has equity in that property of at least 3 times your bond amount. So for example, if I tell you your bond is $2,000, then that means if you want to use a property bond, the net equity in that property has to be at least $6,000, 3 times the bond amount. Okay, so those are the 3 different ways that you may be able to post bond. Now, some of you will have special conditions on your bond that prohibit you from contacting certain people and that prohibit you from going to or around certain places. This special condition will be provided to you on your bond order. Now, should you violate the court's order, your bond will be revoked and you would not be entitled to another bond while you wait for trial. Also, you may have an additional charge of aggravated stalking or influencing a witness or any other charge as the law may provide, and you could be sentenced up to 10 years in prison or fined up to $20,000. So if I tell you that you are to have no contact with an individual, what that means is that you must stay away absolutely, directly or indirectly by mail, email, pager, telephone, social media, or third person from the person, home, workplace, and immediate family members of any witness, including the person that I tell you to stay away from. That's what I mean by that. If I tell you to not go back to a certain location or premises, that means you are not to go back to that location or premises for any purpose whatsoever, so long as your bond condition is in place. Now, if you do have a shared residence with an individual, and I tell you that you cannot return to that particular residence, I will give you the opportunity to go back to that residence to collect your personal belongings, but you will have to do that by scheduling an appointment with the sheriff's office to accompany you at least 10 days from the date that you've been released. Now, for those of you who may use family members to assist you in posting your bond, I will provide them, or the jail will provide them with the information of your bond amount after we have concluded the first appearance calendar here today. However, keep in mind, if a family member is a victim on the warrant and there is a special condition that you are not to have contact with that family member cannot post the bond for you. Now, some of you are charged with offenses for which I am not authorized by law to set a bond for you. In this event, I will schedule a bond hearing. That bond hearing date is going to be July 16th, 2021. And you will appear before a Superior Court judge, and your bond will be determined at that time. If you are currently on active probation, generally this court is not authorized to set a bond for you. We will give your probation officer an opportunity to decide if he or she will file a warrant to revoke your probation. And this is typically done during your preliminary hearing. So everyone will receive a preliminary hearing court date. Essentially, a preliminary hearing is a probable cause hearing. What that means is the purpose of the preliminary hearing is to determine whether or not there is enough evidence or probable cause to justify keeping you detained on your charges until your case goes to trial. For those of you with misdemeanors only, your misdemeanor preliminary hearing date will be July 13th, 2021. If you are charged with felonies or a felony and a misdemeanor, then your preliminary hearing date that I'll be giving you will be July 12th, 2021. So keep that in mind. Also, if you do bond out Your preliminary hearing date is automatically waived, and you will receive a new court date in the mail. Okay, so I will begin calling each of you up before me, one by one. We're going to start with the females. And I'm going to take Nikita Wilson first, since she is being represented by counsel here this morning, so that way Mr. Partridge can go about his Saturday. So if Nikita Wilson can come before me, please.
Your Honor, she one of our fugitives.
Yeah, that's fine. I'll still go ahead and take her.
You want to do it? Okay, all right.
I'll still go ahead and take her.
Okay, all right. Go ahead, you do it.
Thank you.
Yes, I
Okay, good morning. Are you Nikita Wilson?
Yes, ma'am. Good morning.
Okay, and Mr. Partridge, you're here representing Ms. Wilson, correct?
Yes, Judge, that's correct.
Okay, all right. So Ms. Wilson, your particular hearing is called an extradition hearing. All of the rights that I advised everyone of earlier also apply in your case, but your hearing is a little bit different from the other first appearance hearings that I will conduct. You don't have any charges pending against you here in Clayton County. You have been brought to court today because you have charges pending against you in another state, and they are requesting that you return to that state to answer to those charges. Specifically, what is stated on the warrantless arrest affidavit is that you are wanted by the Florida Commission for parole violation, WNO H32749, which is a felony, and Florida has indicated they will extradite. So this hearing is being conducted pursuant to OCGA Title 17, Chapter 13. As you have heard, it is alleged that you were charged with the parole violation in the state of Florida. You have a choice as to whether you wish to contest extradition or to waive extradition and be returned to the other state without going through the formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the state of Florida. The court may not consider allowing you to post a bond. The court may consider allowing you to post a bond, but we are not required to allow a bond in this case. And because you are wanted by the state of Florida, I am not setting a bond in this case at this time. You cannot contest the issue of your guilt or innocence in this state. If you do not wish to voluntarily return to the state of Florida, you may file a writ of habeas corpus to contest the extradition. And the writ of habeas corpus can only contest 4 things. 1, whether the extradition documents are in order on their face. 2, whether you are charged with a crime that actually exists in the demanding state of Florida. 3, whether you are the person named in the request for extradition. 4, whether you are in fact a fugitive from justice. You are entitled to the advice of counsel in contesting the extradition or in deciding whether you will waive extradition. And Mr. Durante Partridge is representing you in these proceedings today. If the state is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days awaiting your extradition. If the extradition is not complete in 90 days, then at that point you will be released. So Mr. Partridge, this is in fact your client, Nikita Wilson, who's been listed on the warrantless arrest affidavit as a fugitive from justice. Is that right, sir?
Yes, Your Honor.
Okay, and do you wish to contest extradition or waive formal extradition and have your client voluntarily return to the state of Florida to answer the charges or the charge that has been brought against her?
Your Honor, I wanted to provide a little bit of context regarding this matter. Ms. Wilson has been in custody for about 30 days at this point. She had a new charge in Clayton County, which she made bond for back on the 11th of this month. So she's been held from the 11th until yesterday when she was booked in, I guess, or rebooked with regard to the fugitive of justice charge or hold that she currently has on her. So she's been in custody for about 30 days thus far, Judge, but again on bond since the 11th of this month. Judge, we've spoken to the parole officer who is over Ms. Wilson's case. They initially indicated that they would pick her up. However, those talks have since declined over the last couple of weeks with regard to them coming together. It's been up in the air. So Your Honor, and I understand the court's position with not setting a bond. I was wanting to see if the court would set a bond so that Ms. Wilson could turn herself in with regard to the matter in Florida. However, if the court is not willing to do that, we will waive extradition and hopefully can expedite, Florida coming to get her, through our efforts on my end. But nonetheless, Your Honor, that's pretty much the background that we have regarding the situation.
You said that Ms. Wilson had been in custody for 30 days already on a different charge.
Yes, Your Honor, I got her a bond. She was originally arrested back in late April. I believe it was April 28th or April 29th. I got her a bond on May the 4th, a consent bond, and her family was able to make that bond on the 11th of this month. And she has been waiting, and we've been waiting to see what Florida would do. It's my understanding that her parole expires within the next 45 to 60 days, if I'm not mistaken, just given the quick math off the top of my head. Say it again, Ms. Wilson, I'm sorry.
I'm sorry, excuse me. It expired on the 16th already of this month.
So it's already expired, okay. So, with regard to that, Your Honor, we were hoping that we could get a bond, but, nonetheless, I understand the court's position with respects to the same.
Okay, and what has the state of Florida mentioned? You said something declined. I didn't catch what you said.
Yes, Your Honor. Initially, when I spoke to her parole officer, Jody Calabro, Officer Calabro, initially, let me rephrase. My client's family spoke to Officer Calabro, who initially stated that she would hold off on putting a warrant out on Ms. Wilson because we're, by condition of her other bond that she's made with Clayton County, she's going into an inpatient counseling treatment upon her release. And thereafter, Officer Calabro changed and stated that she would put the warrant out and they would extradite Ms. Wilson back to Florida. And since she's made bond, I've tried to contact them a couple of times, Officer Calabro, and follow up, as well as Ms. Wilson's family, and we've just not gotten any update as to them coming to get her or not. Initially, again, they were coming, but now they've not given us any further information with respects to timetable regarding that.
Okay, understood. Thank you for that information, counsel. I certainly appreciate it, and you've done well advocating for your client here this morning. I am not going to set a bond at this time. I know you mentioned that in that event, your client will waive the extradition hearing. Is that right?
Yes, sir. She'll waive.
Okay. All right. And what will happen is Ms. Wilson is going to receive several waiver forms. I don't know if you've seen the waiver forms, counsel, but she's going to receive the waiver of extradition form at the jail, and she'll be required to sign several copies of that. And once she signs it, the jail scans it and emails it back to me. And then I sign it as well and send it over to the jail. And then they start processing that paperwork. It's certainly my hope that, with the paperwork waiving the extradition, and then also with your counsel and your diligence and the work that you've been doing, that hopefully you all will be able to get some resolution for your client. I will sign it as soon as I get it here today. So at least that clock starts ticking and you can get the ball rolling with regards to that issue. Is there anything else that you need from me, Mr. Partridge?
No, Your Honor, just to make note, and also for Ms. Wilson, I've explained the extradition process and the waiver process. So Ms. Wilson, please go ahead and sign those documents so that we can get Florida in queue with regard to being on a time clock to come and get you. But otherwise, Judge, that takes care of our business with regard to Ms. Wilson.
Okay, that sounds good. Ms. Wilson, did you have any questions for the court?
No, ma'am, thank you.
You're welcome. Okay, Ms. Wilson, you can be excused.
Thank you.
Mr. Partridge, thank you, sir, for your advocacy. You may be excused. Enjoy your weekend.
Thank you. You also, Judge.
Thank you. Okay, I'll have Ms. Ilonda Banks. Good morning, Ms. Banks. Okay. Give me one moment here. Okay, Ms. Banks, you've been charged with one count of terroristic threats. That bond is set at $10,000. You've also been charged with one count of simple assault. That bond has been set at $5,000. So your total bond amount here today is $15,000. Do you understand the charges in your bond?
No, can you explain it to me?
Yes, ma'am. I will read to you what has been stated on the warrant. For the terroristic threats, it does state that on May 25th, 2021, at 911 Fairway Point Drive, Riverdale, Georgia, you did commit the offense of terroristic threats. And that said, defendant did knowingly and willfully threaten to commit a crime of violence to the person of Akita Richardson and Alana Thompson Ballard, with the purpose of terrorizing said person by threatening to kill Akita Richardson and Alana Thompson Ballard in the presence of Jerome Vaughn. With regards to your charge of simple assault, it states that on May 25th, 2021, at 911 Fairway Point Drive in Riverdale, Georgia, you did commit the offense of simple assault, and that the defendant did commit an act by swinging a bat, hitting the wall and kitchen counters while making threats to harm Akita Richardson and Alana Thompson Ballard, which placed another person, Akita Richardson and Alana Thompson Ballard, in reasonable apprehension of immediately receiving a violent injury. Those are the facts stated that led to the charges being brought against you. Do you believe you'll be able to make bond?
Can I say something with that one?
My question is, do you believe you can make bond, yes or no?
Yes. Can I?
I'm sorry, hang on, Miss Banks, I have a couple of questions for you, okay? So once I ask you my questions and I get the information I need from you, then I'll ask you at the end of this whether you have any questions, and then I'll address your questions at that time. Fair enough?
Yes, ma'am.
Okay. So do you believe you can make bond of the $15,000 total bond that I mentioned to you?
Yes.
Okay, so there is a special condition to your bond. That is to stay away and have no contact with Akita Richardson as well as Alana Thompson Ballard. You also are not to return to or go upon the premises located at 911 Fairway Point Drive in Riverdale, Georgia, 30274. If that is a shared residence, you may schedule an appointment with the sheriff of Clayton County to accompany you to that residence to collect any of your personal belongings that are not in dispute, and that must be done within 10 days of being released. I have reviewed your application for court-appointed counsel, and it appears that based on your responses, you do qualify for a public defender to represent you. Your preliminary hearing date is being scheduled for July 12th, 2021 in courtroom 204. However, if you do bond out, like you believe you'll be able to make bond, that court date will be waived. And you will receive a new court notice in the mail. Just make sure that the clerk's office has your updated address. What questions do you have for me, ma'am?
It's about what you said about that at the apartment.
Okay, so remember earlier when I said, this isn't a day to try your case. So I'm going to caution you about whatever statements you want to make because we don't have a jury here. We don't have the state here. The victims aren't here. So,
Have a good day, okay?
okay, so you don't have any other questions, then have a good day. Thank you. All right, the next person I have is Destiny Bloodsaw.
Hello.
Good morning, Ms. Bloodsaw. You have been charged with improper lane change, violation of the Georgia Controlled Substances Act, possession or use of drug-related objects, possession of marijuana less than an ounce. Your total bond between all four charges is $7,500. Do you understand the charges that I just mentioned to you?
Yes, ma'am.
Do you believe you'll be able to make bond?
Yes, ma'am.
Your preliminary hearing date is being scheduled for July 12th, 2021. If you do make bond, that court date will be waived and you'll receive a new notice in the mail. I received your application for a court-appointed attorney, and after reviewing it, you do qualify, so I have appointed an attorney to represent you. Do you have any questions, Ms. Bloodsaw?
No, ma'am.
Okay, you may be excused. Have a good day. Next person I have is Anjanae Brothwaite. Good morning. Are you Anjanae Brothwaite?
Ajane, right. Yes.
Okay, I did my best. Sorry, your name is beautiful. You have been charged with 1 count of battery and also 1 count of cruelty to children in the 3rd degree. Your total bond amount is $5,000. Do you believe you'll be able to make bond?
Yes, ma'am.
Okay. You do have a special condition to your bond, and that is to have no contact with Brittany and Roberts. Do you understand that condition?
Yes, ma'am.
Your preliminary hearing date is being scheduled for July 13th, 2021 at 8:30 a.m. courtroom 204. However, if you bond out, that court date will be waived and you will receive a new notice in the mail. Do you have any questions, Ms.? Well, actually, hang on. Let me review your application for court-appointed counsel. Okay, so you do qualify to have an attorney appointed to represent you. So I have signed off on that order. Do you have any questions for me?
No, ma'am.
Okay, you may be excused. Have a good day. Next person I have is Brielle Bryant. Are you Brielle Bryant?
Yes, ma'am.
Hey, ma'am, you've been charged with 1 count of possession of marijuana less than an ounce. Your bond is $1,500. Do you understand the charge and your bond amount?
Yes, ma'am.
Do you believe you can make bond?
Yes, ma'am.
Okay. I have scheduled your preliminary hearing date for July 13th, 2021. However, if you are bonded out by then, that court date will be waived and you will receive a new notice in the mail. I received your application for a court-appointed attorney and I have approved it. So there will be an attorney who will reach out to you that is appointed by this court to represent you in this case. Do you have any questions?
No, ma'am.
All right, you may be excused. Have a good day. Next person I have is Kiambria Cannon. Okay, are you Kiambria Cannon?
Yes, ma'am.
Okay, Ms. Cannon, you've been charged with 1 count of improper lane change and 1 count of possession of marijuana less than an ounce. Your total bond amount is $2,000. Do you understand the charge and your bond amount? Is that a yes?
Ma'am.
Okay, do you believe you'll be able to make bond?
Yes, ma'am.
All right, I have scheduled your preliminary hearing date for July 13th, 2021 at 8:30 a.m. However, that court date will be waived in the event that you bond out. I have also reviewed your application for a court-appointed counsel, and you do qualify to have the court-appointed attorney to represent you. So I have signed off on that order. Do you have any questions for me, Ms. Cannon?
No, ma'am.
Okay, you may be excused. Have a good day. Thank you.
You're welcome.
The next person I have is Ayanla Challenger. Good afternoon. Are you Ayanla Challenger? Okay. You have been charged with 1 count of driving on a suspended license, as well as a stop sign violation. Your total bond amount is $2,000. Do you understand the charge and the bond amount?
Yes, what are we gonna stop sign?
I can't hear you.
You said a stop sign violation?
I'm sorry, failure to yield. Stop or failure to yield a sign is what it states. Do you understand that?
Yeah.
Okay. Do you believe you'll be able to make bond?
I'm not sure.
I have scheduled your preliminary hearing date for July 13th, 2021. So if you are still incarcerated at that time, you will be brought up before the court to have a preliminary hearing on whether or not there's enough probable cause to keep you detained on the charges that I mentioned to you. Did you complete an application for a court-appointed attorney? Did you fill out some information about your employment and income?
Yes, I did.
Okay, give me 1 second. Let me locate that.
Okay.
Okay, are you employed, Ms. Challenger? You didn't indicate your employment status on here.
No, ma'am, I'm not employed.
Okay, I am going to appoint an attorney to represent you. And so that attorney will be in contact. Do you have any questions for me?
Yes, I have one question about the jobless suspended license. The officers, they refused to call Spalding County to confirm that I did have a permit. I have a permit that the judge, Josh Thacker, gave me, and it had a court seal on the paper as well. I guess just because it didn't show up in their system, they were, I don't know.
Okay, so the warrantless arrest affidavit is indicating that the officer noted that your license was suspended November 7th of 2019 and February 11th of 2020. So the information that you just mentioned to me, that will be good information you need to talk to your attorney about. And your attorney should be able to give you advice on what you need to do next to dispute these charges and resolve your case, okay?
And that's gonna be until July 13th.
So if you're still incarcerated, your preliminary hearing date is scheduled for July 13th.
So
So
they can give me any time between now through.
I can't hear you. Speak up just a little bit more.
Oh, I'm saying, so I should be seeing them like in a few days, or you don't know when?
Okay, so your next court date where you'll appear before the court, if you are still incarcerated, your next court date is going to be July 13th of 2021.
Yeah, I know, but I'm saying, ain't they supposed to see you before then?
Oh, you're saying, will your attorney see you before then?
Yeah.
That I do not know, because I don't work for the public defender's office, so I'm not sure. But I just know that they will reach out to you if you are still incarcerated. Okay, now if you want to waive that preliminary hearing date, you can waive it, and you won't have that preliminary hearing date, and you could possibly get a court date before then, but that's no guarantee. Do you want to do that, or do you just want to keep this July 13th court date?
I'll just keep it.
Okay, so like I mentioned, if you're still incarcerated by then, you will be brought up before the court and your court-appointed attorney will reach out to you soon. All right, have a good day. The next person I have is Rochelle Cheatham. Good morning, are you Rochelle Cheatham?
Yes, ma'am. Good morning. How are you?
I'm well, how about yourself?
Ma'am, I could be better, but I'm praying.
Okay. Well, you have been charged with 1 count of criminal trespass. That bond has been set at $3,000. Do you understand the charge and the bond amount?
How much would it have to be with the bail bonds?
Up to 15% probably, I'm not sure. 15% may be like $450. Don't quote me on my math, but you'll have to call some bonding companies and find out exactly how much they charge if your bond is $3,000. Okay, so with that information, do you believe you'll be able to make bond?
Ma'am, I'm about to try to get on the phone now. When I was arrested, I had gave my phone and my keys and stuff to family, so I'm trying to get a hold of family now. But I have the money. I have the money just at my house. So it's just a matter of calling and getting someone to get the money for me. But I have the money, yes.
Okay, and your preliminary hearing date, if for whatever reason you're not able to make bond, your preliminary hearing date is July 13th, 2021. But if you make bond, that court date will be waived and you'll receive a new court date in the mail. Now, are you requesting that I consider you for a court-appointed attorney?
Yes, ma'am.
Okay, let me locate your application here. I didn't see it earlier, but give me 1 second. Are you currently working, Ms. Cheatham?
Yes, ma'am. I work 7 days a week.
Okay, what did you indicate on your, because I'm not locating your application. What did you indicate as your gross monthly income per month?
I make between 2,500 and 2,800 a month. I'm a server, ma'am.
I'm sorry, you what?
I said I'm a server, a waitress.
Okay. All right, so I am going to go ahead and appoint an attorney to represent you. And so that attorney will be in contact with you. Do you have any questions for me?
No, ma'am.
Okay, you may be excused. Have a good day.
Thank you, you too.
You're welcome. The next person I have is Kiara Gibson. Hello, are you Kiara Gibson?
Yes, ma'am.
Okay, you have been charged with 1 count of giving a false name. Your bond is $1,000. Do you understand the charge and the bond amount?
Yes, ma'am.
Okay, do you believe you'll be able to make bond?
Yes, ma'am.
All right, I've scheduled your preliminary hearing date for July 13th, 2021. However, it will be waived in the event that you do make bond like you believe you'll be able to. Also, I am appointing an attorney to represent you. I have approved your application. Do you have any questions for me?
No, ma'am.
Okay, you may be excused. Have a good one. The next person I have is Tammy Glenn. Hello, ma'am. Are you Tammy Glenn?
Yes, ma'am, I am.
Okay. I have one charge here for you. It is criminal trespass, and that bond amount is $2,500. Do you understand your charge and the bond amount?
I do.
All right. I do have a condition listed here, and that is to stay away and have no contact with LaDerrick Furlow. And that condition will be in place so long as this bond condition is in place and until your case is resolved. Do you understand that?
Yes, ma'am. I do have a question. I work from home, that's our home that was just purchased. So what would I need to do to get my items so that I can work if I can't be at the home?
Okay, so you all do reside together?
We're married. We just got married 2 weeks ago.
Okay, hold on one second. Let me take a look at your file.
Yes, ma'am.
Is that the 8871 Jimmy Lee Circle address?
It is. Yes,
Okay.
ma'am.
All right, so I am going to indicate on here that you can go back to collect your personal items. And so once you are released, just contact the Clayton County Sheriff's Office to escort you. Do that within 10 days of being released. And you can go back and get any undisputed personal items. Undisputed means that Mr. Furlow and you aren't fighting about whose stuff it is. Okay, so you can get any undisputed personal items. I'm going to indicate that on your bond condition. All right.
Yes, ma'am.
Your preliminary hearing date is July 13, 2021, which will be waived once you bond out. I have appointed an attorney to represent you based on your application for court-appointed counsel. Do you have any other?
Yes, ma'am. I have one last question. If my husband goes to court prior to that date, is there anything that can be done about this? Or we have to just wait till the court date?
Well, the court date is, if you bond out, the court date is going to go away. So
Yes.
you're not going to have that court date and you'll receive a new one in the mail. But talk to the attorney that I appointed to represent you, and the attorney will know how to contact the state or the prosecutor's office to negotiate something.
Okay,
As you all could possibly work out a resolution prior to any court date.
that's what I'm asking. Yes, ma'am. I appreciate
Yes.
that.
No problem. All right. You have a good day, Ms. Glenn.
You do the same.
Thank you. The next person I have is Jewel Laney.
Hello.
Are you Jewel Laney?
Yes, ma'am, I am.
Okay. All right. Give me one moment, Miss Laney. Okay, Ms. Laney, you have been charged with 1 count of aggravated assault with a deadly weapon, 1 count of criminal damage in the 2nd degree, 1 count of battery, as well as 1 count of simple battery. The battery charges each have a bond amount of $6,000 apiece. I have denied bond on the aggravated assault with a deadly weapon, and I have also denied bond on the criminal damage in the 2nd degree. Do you understand the charges and what I've mentioned about bond?
No, ma'am, I don't, because, I didn't commit any of these crimes. I'm thinking somebody used my name. This isn't something that I did. So I don't understand anything, and for me not to have a bond, I'm very lost.
Okay, are you Jewel Lee Laney?
Yes, ma'am, I am.
Okay, is your date of birth 5/11/89?
Yes, ma'am, it is.
Okay, I'm just gonna read to you. If you want me to, I can read to you what's been listed on the warrants. Do you want me to read that?
That's fine.
Okay, it does state that for your aggravated assault charge, it states that on May 7th, 2021, at 104 Alexander Court in Riverdale, Georgia, that the defendant did commit the offense of aggravated assault with a deadly weapon, and that said accused did make an assault upon the persons of Justin Flournoy, Keisha Holmes, and Shunqueries Anderson with a motor vehicle, a Toyota 4Runner with tag RZA 9775, which when used offensively against another person is likely to result in serious bodily injury. Said offender did drive her vehicle at a high rate of speed through a neighborhood, striking a parked vehicle, which was a Pontiac G6 with a tag number RSA 5003, that all 3 victims were hiding behind. The parked vehicle then struck all of the 3 individuals as the offender fled the scene.
That's not true.
In regards to, and again, you're not here to plead guilty or not guilty. I'm just giving you the factual basis that led to these warrants being taken out. The second offense of criminal damage to property in the 2nd degree, which is being charged as a felony, states that on May 7, 2021, at 104 Alexander Court in Riverdale, Georgia, the defendant did commit the offense of criminal damage to property in the 2nd degree, and that the defendant did intentionally damage the property of Keisha Holmes, a Pontiac G6 tag number RSA 5003, without said owner's consent, by driving her own vehicle, a Toyota 4Runner tag RZA 9775, with said damage exceeding $500 due to front end damage to the right side of the vehicle, as well as damaging the driver's side door. As it relates to the battery, physical contact, which is being charged as a misdemeanor, it states that on May 7, 2021, at 104 Alexander Court in Riverdale, Georgia, the defendant did commit the offense of battering, physical contact, provoke, and that the defendant did intentionally cause substantial physical harm to Justin Flournoy and Shunqueries Anderson, being the ex-girlfriend of Justin, causing swelling to Justin's head and swelling to Shunqueries' wrist. Intentionally drove her vehicle into a parked vehicle that both victims were hiding behind. In regards to the 4th offense, which is the misdemeanor simple battery, it states that on May 7, 2021, at 104 Alexander Court in Riverdale, Georgia, the defendant intentionally did make contact, physical contact, of an insulting or provoking nature with Keisha Holmes by driving her vehicle into a parked vehicle, hitting Holmes with the car. The victim and offender were unknown to each other. So those are the factual statements that led to these 4 warrants. As I've mentioned, I've denied bond on the 2 felony counts, which is the aggravated assault with a deadly weapon and the criminal damage in the 2nd degree. There is a bond listed for each battery offense at $6,000 apiece. In the event that you ultimately get bond, there will be special conditions, which is to have no contact with Justin Flournoy, Keisha Holmes, and Shunqueries Anderson, and not to return to 104 Alexander Court in Riverdale, Georgia. Your preliminary hearing date is scheduled for July 12th, 2021. Your bond hearing date is scheduled for July 16th, 2021. Are you requesting that you be considered for a court-appointed attorney, or do you plan to hire your own attorney?
Do I have to sit in here until July 12th?
Ms. Laney, I asked you a question. Do you plan to hire your own attorney, or would you like to be considered for a court?
Not sure. I'm not sure yet.
Okay, I've appointed an attorney to represent you. And that attorney will reach out and be in contact with you. And the questions you have about what you should do next, you can talk to your attorney, and your attorney will be able to advise you. Do you have any other questions?
Yes, I'm going to have to sit in here until you say I have a bond hearing.
Your bond hearing date will be July 16th, 2021. And so you'll appear before the court at that time. Now, because I have appointed an attorney to represent you, certainly you can talk to your attorney prior to that to see if there could be a consent bond worked out prior to that court date. All right. You may be excused, Ms. Laney. Have a good day. The next person I have is Rashida Lester.
I'm just, get all these charges.
Man, you can go to the pod. Go to the pod. Come on now.
Rashida Lester.
He's coming, man.
Okay, thank you.
Oh, come on. You messed it.
I won.
Ma'am, she's 24.
Okay.
Still want to see her? I mean, come on, Ms. Lester. You gotta be seen before the judge. Come on.
Okay, are you Rashida Lester?
It's not my name, but I answered to it.
Okay. You have been charged with simple battery and obstructing an officer. Your total bond amount is $7,000. Do you believe you'll be able to make bond?
I don't know.
All right. As a condition to your bond, you are to have no contact with D. Owens. I have scheduled your preliminary hearing date for July 13th, 2021. If you do make bond, that court date will be waived and you'll receive a new notice in the mail. I have appointed an attorney to represent you. I'm sorry, Ms. Lester. Hang on, Ms. Lester, I wasn't done. I've appointed an attorney to represent you, ma'am, and that attorney will be in contact with you, okay? Now I'm done. Have a good day.
State your name to the judge. Have a seat, Lester.
My name is Michelle Brooke Vining.
You gotta walk in there.
I need to go all these seats to take in case you understand that.
I'm sorry, what was your name?
Michelle Brooke Vining.
All right, so Ms. Vining, you have been charged with one count of violation of the Georgia Controlled Substances Act, possession of Schedule I controlled substance, as well as one count of violation of the Georgia Controlled Substances Act, manufacture, sell, distribute, deliver of controlled substance. I have denied bond on both of those felony charges. It indicates that you are actively on an 8-year probation sentence out of Clayton County as of September 6th of 2018. You also have a misdemeanor charge of possession of a drug-related object that does have a bond for $500. But as I mentioned, I've denied bond on the first two charges. I have scheduled 2 court dates for you. You're going to have a preliminary hearing date scheduled for July 12th, 2021. And you're also going to have a bond hearing date scheduled for July 16th, 2021. You plan to hire your own attorney to represent you, or are you seeking the assistance of a court-appointed attorney?
Well, I'll go for the court-appointed attorney until I hire my own attorney.
Okay, so let me review your application. Give me 1 second here.
Also,
Give me 1 second and I'll ask you if you have any questions, Ms. Viney. Let me take a look at your application. Okay, so I have reviewed your application, Ms. Viney, and I am going to appoint an attorney to represent you in these proceedings. In the event you do hire your own counsel, just make sure you notify the court-appointed attorney and the courts accordingly. What question do you have for me, ma'am?
I was only under the impression that I was being booked under 2 violations of probation. I've only been fingerprinted under 2 violations of probation.
Well, the warrants that I have don't indicate any probation violations. It could be that maybe your probation officer, has already issued warrants for your probation violation. I'm not sure, because I do show that you are on active probation, but that is why I read the charges to you that I have in front of me. So the warrants that I have were signed off on just yesterday, May 28th, 2021. Okay. You have any other questions?
No.
All right, you may be excused.
Okay, thank you. So, wait, ma'am,
You're welcome.
go to court when?
So you have court on July 12th, 2021. That's your preliminary hearing date to determine whether or not there's enough probable cause to keep you incarcerated. And then you also have court July 16th. That's for your bond.
And they could give me bond being on probation?
I'm sorry?
They could even give me bond if so on probation?
I mean, it's going to depend on the judge at that time, and also it's going to depend on what your probation officer states as well.
Okay, thank you.
You're welcome. Have a good one.
Your Honor, this next one, Ms. Vasquez, she's 24, so you're gonna have to just be patient with her also. Ms. Vasquez. step over the
Okay.
phone.
Now, officer, what about, it was a couple of other ones. They may be OTB, but Tara Janae Peppers.
OTB.
Okay. Sidacia Small.
Small, she's right here.
Okay, can I get Miss Small first, please?
Yeah, have a seat, please. Ms. Vasquez, have a seat.
They got chakras in it, not small. Hey, how are you?
Good afternoon. Are you Sidacia Small? Okay, you have been charged with 1 count of possession of marijuana less than an ounce. That bond is set, that bond is set at $1,500. You understand your charge and your bond amount?
Yes.
Do you believe you'll be able to make bond?
Yes, ma'am.
Your preliminary hearing date is being scheduled for July 13th, 2021. And that court date will be waived, and you'll receive a new court date in the mail if you do ultimately bond out. Are you seeking to hire your own attorney, or would you like to be considered for a court-appointed attorney?
A court.
Okay. All right, you do qualify, so I am approving your application, and I have appointed an attorney to represent you. You have any questions for me, Ms. Small?
Yeah. Okay, it don't have to be exact calculations, but if with bonding, a bonding place, it should estimate to like how much? 15.
And for the spirits, not in. It's the spirits. Okay, keep it. What are you gonna do? You ready me? John Sharper, she hear this? What? You hear this from book?
So, if, for example, just for example, if the bonding company was to charge you 15% of the $1,500, that ends up being $225.
Disabled mentally and physically. In the name of God, I am. Thank you.
All right, you're welcome. Have a good day.
I'm physically and mentally ill. Legally, yes,
Okay,
I am.
and before Ms. Vasquez comes back up, is there LaQuisha Wheelock
Yes.
there?
You know, see that?
I'll go ahead and take Ms. Wheelock.
La familia y todo el mundo en el mundo.
Vasquez.
I'm sorry, deputies, I cannot hear. It's hard for me to hear. Okay, so Ms. Wheelock, you have been charged with 2 offenses. The first one is failure to yield while turning left. That bond is set at $500. Your second charge is DUI alcohol less safe. That bond is set at $5,000. So your total bond amount is $5,500. Do you believe you'll be able to make bond?
Yes, ma'am.
Okay. I have scheduled your preliminary hearing date for July 13, 2021. If you do bond out though, that court date will be waived and you'll receive a new notice with a new court date in the mail, okay? Are you requesting the assistance of a court-appointed attorney or did you plan to hire your own attorney?
Court-appointed attorney?
Okay, let me review your application.
Okay.
Okay, based on your statements on your application, you do qualify, so I am appointing an attorney to represent you. Do you have any questions for me, Ms. Wheelock?
Not at this time, ma'am. Thank you.
You're welcome. Have a good day.
Likewise.
Thank you.
Vasquez.
Okay, is she the last female?
Yes, ma'am. That's on the judge.
Okay.
Ma'am, I'd like to tell you on a recorded line, I'm mentally and physically disabled and
Okay, so Ms. Vasquez, just hang on. I just need to provide you with some information. As I mentioned, my name is Judge Farrey. This hearing that we are having today is what is called an extradition hearing. All of the rights that I advised everyone of earlier also apply to you in this case, but your hearing is a little bit different from the other first appearance hearings that have just taken place. Ms. Vasquez? Hang on, Ms. Vasquez. Hold on, because I have to be able to tell you what's going on so I can help you, okay? So hold on so I can help you. Now, you don't have any charges pending against you here in Clayton County. You've been brought to court today because you have charges pending against you in the state of Florida. Seminole County Sheriff's Office, state of Florida, for conditional release violation. And that's on warrant number 21246 CFA, which is a felony. And Florida has indicated that they will extradite you back to Florida. Now you are being charged with the fugitive from justice, as I've just mentioned. This hearing is being conducted pursuant to OCGA Title 17, Chapter 13. As you've heard, it is alleged that you are charged with conditional release violation in the state of Florida and Seminole County. You have a choice as to whether you wish to contest extradition or to waive extradition and be returned to the other state without going through the formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the other state. Now, the court may consider allowing you to post a bond, but the court is not required to allow bond in your case. And as you are wanted by the state of Florida, I am not setting a bond in your case at this time. If you do not wish to voluntarily return to the state of Florida, you may file a writ of habeas corpus to contest the extradition. The writ of habeas corpus can only contest 4 things. 1, whether the extradition documents are in order on their face. 2, whether you are charged with a crime that actually exists in the state of Florida, where you are being demanded. 3, whether you are the person named in the request for extradition. And 4, whether you are in fact a fugitive from justice. You cannot contest whether you are guilty or innocent in this state. You are also entitled to have the advice of an attorney in deciding whether to contest extradition or waive extradition. If the state of Florida is unable to extradite you within 30 days, you will be committed to the county jail for an additional 60 days while awaiting your extradition. If extradition is not completed in 90 days, then you will be released from the Clayton County Jail. So Ms. Vasquez, at this time, I'm just going to ask you a yes or no question. Do you wish to contest extradition?
No.
Okay, so you wish to waive formal extradition and voluntarily return to the state of Georgia, the state of Florida to answer to the
Ma'am, I have a life-threatening disease. I should have been in Florida a long time ago, and they've been holding me hostage here. So I need to return to Florida so I could go to Gainesville, and Gregory Pelham and Ron Book are my attorneys. And what they've done here is against the law, and I'm mentally and physically disabled, so I need to, as an emergency order, be in Florida, 911.
Okay, so what you're gonna receive is you'll receive several copies of the waiver of extradition form, Ms. Vasquez. Go ahead and sign those, and as soon as you sign it, I'm gonna sign it today, and it will be sent back over to the jail so we can start that processing immediately. Okay, all right, that will be all, Ms. Vasquez. You may be excused. Have a good day. All right, so if that's all for the females, we'll start with the male pod. Thank you, Deputy.
Boykin.
Okay, so it looks like the first person I have is Sherman Boykin. Okay, good afternoon, Mr. Boykin. If you can, yeah, thank you. I was going to say I can only see his neck. All right. So, Mr. Boykin, you have been charged with 1 count of criminal trespass, damage to property. Your bond is set at $3,000. Do you understand you're charging your bond amount? Speak up just a little bit for me. Okay, do you believe you'll be able to bond out? Okay, there is a condition to that bond, and that is to stay away and have no contact with Giovanna Nicolai. And also you cannot return to 4370 Old Dixie Highway, Atlanta, Georgia, 30354. Do you understand that condition?
Correct.
Okay. Is that a shared residence, that location?
Actually, that was my old job.
Oh, okay. All right. So are you planning to hire your own attorney, or do you plan to, are you requesting a court-appointed attorney?
A court attorney.
Okay. I am approving your request for a court-appointed attorney based on your responses on your application. So that attorney will be in contact. I have scheduled a preliminary hearing date in your case, and that will be July 13th, 2021. But if you bond out, that court date will be waived and you'll receive a new court date in the mail. Do you have any questions for me, Mr. Boykin?
Yes, ma'am.
What's your question?
All right. Giovanna Nicole, that's my baby mama, but that's the only person I have. I don't talk to my mama or my sister or nobody. So she has my phone, my money, and everything. That's basically the only person I have on my side who can come post my bond for me. Cause like I said, I don't have contact with none of my family, my mom or my sister. So I only have her.
Well, I don't know what to tell you. Maybe she can, contact some other people on your behalf, but that's something that you have to figure out, sir. Given these circumstances, that she has been noted as the alleged victim in the case. So I'm gonna leave this no contact provision in here. Like I mentioned, maybe someone else can work it out for you, but I cannot remove that condition at this time. I did appoint an attorney to represent you, so maybe you can talk to your attorney and see what options you have. But I am not inclined to remove that condition at this time.
Okay, so how do I supposed to get my money from her so I can bond up?
I appointed an attorney to represent you, and your attorney can advise you and counsel you. You have any other questions about your bond or your charges?
No, that's it.
All right. Have a good day, Mr. Boykin. Good afternoon. May I have your name?
Britain.
Okay, one moment, Mr. Britton. Okay, Mr. Britton, you've been charged with 1 count of driving on the wrong side of the road, 1 count of possession of marijuana less than an ounce. Your total bond amount between those 2 charges is $2,000. Do you understand your charges and your bond amount? Do you believe you'll be able to make bond?
Yes, ma'am.
Your preliminary hearing date I've scheduled for July 13th, 2021, but if you bond out like you believe you'll be able to do so, that court date will be waived and you'll receive a new court notice in the mail. I've reviewed your application for a court-appointed attorney and I am approving it. So I have appointed an attorney to represent you and that attorney will be in contact. Do you have any questions for me, Mr. Britton?
No.
All right, you may be excused. Have a good day. Good afternoon. May I have your name?
Courtney Coachman.
That Courtney Coachman.
Mm-hmm.
Okay. All right, Mr. Coachman, you have been charged with 1 count of violation of the Georgia Controlled Substances Act, as well as 1 count of possession of drug-related objects. I've dismissed the possession of drug-related objects for lack of probable cause on the warrantless arrest affidavit, but I have set a bond on the violation of the Georgia Controlled Substances Act of $5,000. Do you understand the bond and the charge?
Yes, ma'am.
Do you believe you'll be able to make bond?
Hopefully, yes.
Okay. I've approved your, I'm sorry, I need one other piece of information from you. Looking at your application for a court-appointed attorney, you indicated that you are employed. Are you in fact employed?
Yes.
Okay. You didn't list the income amount. How much do you earn per month? You just put NA.
Only because like I do deliveries like Uber Eats, so it ranges from anywhere to like 100 to 1,200 times the amount of days in a month. So
Guesstimate for me in a month period. How much do you think?
Probably like 2,000.
Okay.
I also receive disability too.
Okay. I've approved your application, so I am appointing an attorney to represent you. Your court date is being scheduled for July 12th, 2021. But if you are able to bond out, that court date will be waived and you'll receive a new notice in the mail. Do you have any questions for me, Mr. Coachman?
No, ma'am.
All right, you may be excused. Have a good day. May I have your name? Okay, Mr. Davey, you have been charged with violation of pedestrian roadway, as well as 1 count of possession of marijuana less than an ounce. Your bond between those charges is $2,000. Do you understand the charges and the bond?
No.
Do you believe you'll be able to make bond?
No. Okay.
Okay, your court date has been scheduled for July 13th, 2021. That court date will be waived in the event that you do bond out, like you believe you'll be able to do so. And I did receive your application for a court-appointed attorney. Based on your responses, I am appointing an attorney to represent you. He or she will be in contact with you in regards to your case. Do you have any questions for me, sir?
Yes, I do.
What's your question?
When will they reach out to me?
That I don't know, unfortunately. It usually it's within a few days. Sometimes it can be a couple of weeks. What I would probably encourage you to do is maybe reach out to the public defender's office just to see who your assigned attorney is and obtain that person's contact information when you bond out. Okay. All right. Any other questions?
Yeah.
All right. You may be excused. Have a good day. Hello, may I have your name? Okay, Mr. Gleason, you have been charged with 1 count of aggravated assault and 1 count of possession of marijuana less than an ounce. Your total bond between those 2 charges is $21,500. Do you understand the charges and the bond amount? Okay, do you believe you'll be able to make bond, Mr. Gleason? Okay, you do have a condition to your bond, and that is to stay away and have no contact with, I think it's Q Jamie Joseph. I believe it's QJAMEI Joseph. Do you understand that condition? You are not to return to or go upon the premises located at 330 Arrowhead Boulevard, apartment 15G in Jonesboro, Georgia. Do you understand that condition?
Yeah.
Okay, is that a shared residence where you would need to go back with the sheriff's office to get your belongings?
That's my own place. That person doesn't live there.
Okay, so
So what you just said, does that still go?
I'm sorry.
So what you just said, that I'm not allowed to go there, does that still, because that person just was visiting.
Okay, hang on, let me review the file. Let me review your file real quick here and see what has been stated. Okay, so I reviewed the warrantless arrest affidavit as well. It does not indicate that it's a shared residence. So I will remove the condition about not returning to that location. But like I mentioned, the condition about not having any contact with the alleged victim is going to remain in place. So if, wherever Mr. Joseph is, you cannot be there and have any contact with him. Understood? I'm sorry?
I said, thank you, I appreciate it.
Oh, no problem. Hang on. Let me give you some more information here. Your scheduled preliminary hearing date is July 12th, 2021 at 8:30 a.m. Now, if you do bond out like you believe you'll be able to do so, that court date will be waived and you'll receive a new notice in the mail. I've reviewed your application for a court-appointed attorney, and I just had a question here because I can't really read your handwriting. It says that you are employed, but I'm not able to determine how much you earn per month. How much do you earn each month?
Between 25 to 3,000.
Okay, I'm gonna approve you for a court-appointed attorney, Mr. Gleason, and so he or she will be in contact with you. Do you have any other questions for me?
No, I don't. Thank you.
Okay, you're welcome. Have a good day. Good afternoon. May I have your name?
Okay.
Say that one more time for me.
James Kelly.
Oh, James Kelly. Okay, one moment. Okay, Mr. Kelly, so you have been charged with one count of window tint violation. It's a misdemeanor. The bond is set at $500. You've also been charged with possession of MDMA. I've denied bond on that charge. You've also been charged with possession of firearm during a felony. I've denied bond on that charge. And you've also been charged with possession of a firearm by a felon. I've also denied bond on that charge. I'm showing that there is a suspended sentence of 5 years out of Fulton County. And that started, or that went into effect December 16th, 2019. So I'm not authorizing a bond at this time. I am scheduling a bond hearing date for you. That's going to be July 16th, 2021. Your preliminary hearing date is going to be July 12th, 2021. Are you going to be hiring your own attorney, or do you want to be considered for an appointed attorney?
You can appoint me.
Okay, it says you're employed, but you didn't indicate how much you earn per month. Do you know how much you earn per month?
No, I just started.
Okay, I'm gonna go ahead and appoint an attorney to represent you. And so he or she will be in contact. Do you have any questions for me, Mr. Kelly?
No, ma'am.
Okay, you may be excused. Have a good one. May I have your name, please?
Paul William Lorenzen.
You said Paul William Lorenzen?
Yes, ma'am.
Okay. Do you know what you're charged with, Mr. Lorenzen?
I believe it's child molestation.
Okay. Yes, sir. So it's one count of that. I am not authorizing bond at this time. I have scheduled a bond hearing date for July 16th, 2021. I have also scheduled a preliminary hearing date for July 12th, 2021. Based on your application, I had a couple of questions, your application for a court-appointed attorney. I understand you've indicated that you're retired, but you do have some income. What is your gross monthly income, sir?
8,000 a month.
I'm sorry?
8,000 a month. I'm retired.
Okay. I'm sorry, sir?
Retired military.
Okay. All right. So based on your income, you don't qualify for a court-appointed attorney, Mr. Lorenzen, so you'll be.
I have already got an attorney present from Griffin, Mr. Singleton.
Okay, what's the attorney's name?
Mr. Singleton.
Do you know his first name?
I think it's Harry Singleton. Not sure.
Okay. I'm just gonna indicate it on the application you filled out for a court-appointed attorney that you have hired Attorney Singleton. Okay, so I've given you your court date, sir. Do you have any questions of me?
Am I released today, or do I have to stay in incarceration?
No, sir. Earlier I mentioned I am not authorizing bond, meaning I'm denying you bond at this time, but I've scheduled a bond hearing date for July 16th, 2021, and I've scheduled a preliminary hearing date, July 12th, 2021. So unless your attorney works out something before those court dates, you will remain incarcerated and you will be brought before the court on those dates. Okay.
Question, ma'am, is I'm a diabetic and I have to have my medication every day, insulin, and I have not been able to get that. So I don't know how I'm going to get my medicine through being incarcerated when everything's left at home.
Okay, so you should be able to use the phone at the jail to contact whoever you need to contact to bring your medication up to the jail for you. Okay, so when you're released here before me, you'll have an opportunity to use the phone, so that way you can make those arrangements to get your medication. Okay, and then of course, if you have any issues or have any other questions, I'm sure Attorney Singleton should be able to help you.
Okay.
All right, thank you. Have a good day, sir.
Yes, ma'am.
May I have your name, sir?
Secondie Adius Landry.
Okay, Mr. Landry, you have been charged with 1 count of criminal trespass. That bond is $3,500, as well as 1 count of disorderly conduct. That bond amount is $1,500. So your total bond is $5,000. Do you understand what I've mentioned about your charges and your bond amount?
I would like to for you to review my charges as to what the criminal trespassing is. The only reason I say that is because I never was banned from property or anything. So I was just like a paying consumer. So that's why I was wondering, what.
Okay, no problem. You have a right to certainly know what facts led to the charges that were filed against you. So I'll definitely read those facts that's stated on the warrantless arrest probable cause affidavit. It states that on May 28, 2021 at 8063 Terra Boulevard in Jonesboro, Georgia at approximately 7:50 a.m. The defendant did commit the following: knowingly and without authority entered the victim's car. Paula Marie Grisby went through the trunk and picked up items. Hang on. You want me to read it? So hang on. Took Gatorade drink and a computer keyboard. Acted in a violent manner and used vulgar language towards the coin laundry staff, throwing items on the floor of said restroom. So those are the allegations that were made. Based on that, I have listed a special condition of your bond, and that is to stay away and have no contact with Paula Marie Grisby. Also, you are not to return to or go upon the premises located at 8063 Terra Boulevard in Jonesboro, Georgia, which is the coin laundry. I have reviewed your application for a court-appointed counsel, and I have appointed an attorney to represent you, so that attorney will be in contact with you. I have also scheduled a preliminary hearing date for you, and that hearing date will be July 13th, 2021 at 8:30 a.m. Do you have any questions about your bond amount, your court-appointed attorney, or the bond conditions, sir? And so what question do you have about your bond amount? Because again, remember, this is not a time to try your case, and I'm not here to try your case, okay? So you would need to talk to your attorney about any questions that you may have in regards to your defense. Now, do you have a question about the bond amount, the court-appointed attorney, or your court date?
Yeah, because when I was coming to go wash my clothes, I told you.
That's not what I asked you.
Oh yeah, okay. Well, I'm sorry. I just complimented someone who got upset.
Mr. Landry, I'm gonna assume you don't have any questions about your bond.
About my bond. The criminal trespass, It's out of the amount of $500 or whatever going through a bond company and stuff like that. And when will I be able to talk to a lawyer you know, about the dropping of certain stuff? I would like dropping of charges and things like that, because
So your attorney,
they didn't tell me nothing about it.
Mr. Landry, I've heard your question. I've heard your question.
No, I was just asking who Paula. Hey, okay.
Okay, hang on, deputies. I've muted him, but let me at least let him, let me at least answer his question. So Mr. Landry, I'm just gonna answer your question. Like I mentioned, your total bond amount is $5,000. And yes, you can go through a bonding company and they can charge you up to 15%. I don't know the exact amount, so you would have to ask the bonding company. In regards to the attorney will reach out to you. If you are still incarcerated, that attorney will reach out to you at the jail before your court date, or on or by your court date, which is July 13, 2021. If you've already bonded out, they'll reach out to you based on the contact information that you've listed on your application. Okay? Have a good day, Mr. Landry. I'm sorry, if you can unmute now, deputies.
Okay, man.
And may I have your name, sir?
My name is Omar Lawman.
Okay, Mr. Larmond, you have been charged with 1 count of obstructing an officer and 1 count of improper passing. Your total bond amount is $2,000. Do you understand what I've mentioned as far as your charge and your bond amount?
Yes, ma'am.
Do you believe you'll be able to make bond?
Yes, ma'am.
Your preliminary hearing date is being scheduled for July 13th, 2021, but if you make bond, that court date will be waived and you'll receive a new notice in the mail. I have reviewed your application for a court-appointed attorney and you do qualify. So I've appointed attorney to represent you and that attorney will be in contact. Do you have any questions, Mr. Larman?
Yes, ma'am.
What's your question, sir?
Am I not allowed to call 911 if more than one police officer approaches my car?
Sir, hang on. Because like I mentioned, and this is for everyone else who's sitting in that room that's coming behind you. Like I have mentioned, my goal here is to tell you what your charges are, tell you what your bond is, give you a preliminary hearing date, as well as determine whether or not you qualify for the assistance of a court-appointed attorney. We are not here to have a jury trial today. We are not here to have a trial. You will have an opportunity to prepare a defense on your behalf. I have appointed an attorney to represent you. So as far as any questions about the facts and what your rights are as it relates to what allegedly happened that day, you need to speak with your attorney, Mr. Larman. Do you understand that?
Yes, ma'am.
Okay, so let me ask you, do you have any questions about the court date that I've just given you, the bond amount I've just told you about, or the fact that I've appointed an attorney to represent you?
No, ma'am.
All right, have a good day. May I have your name, sir?
Aquanis Malek.
I'm sorry?
Aquanis Malek.
Okay. So, Mr. Millett, you have been charged with simple battery, violation of the Georgia Controlled Substances Act. That includes possession of more than 1 ounce of marijuana, as well as possession of marijuana with intent to distribute. You've also been charged with possession of a drug-related object. I have set a bond for $5,000 on the simple battery charge, but I am showing there's a You're on active probation, 4-year probation that started October 28th of 2019 out of Fulton County. So I am denying bond on the other 3 offenses. If you do ultimately get bond, you will have a no contact and stay away condition. And that is to not have any contact with McKenna Clark and to not return to the 6358 R241 Old Dixie Road in Clayton County, Georgia. I am scheduling a court date for your bond, and that's going to be July 16th, 2021. So you'll be able to have bond determined at that time. I have also scheduled a preliminary hearing date for you, and that date is July 12th, 2021. I am appointing an attorney to represent you as well, so that attorney will be in contact with you. Do you have any questions for me, Mr. Millett?
Yes, ma'am. I have court on the 5th of June, so I'm trying to see like how would that work?
Where do you have court?
Well, just 2 weeks ago, I was in pre-trial because I had got caught with a little marijuana, and they gave me 3 misdemeanors. So,
what county?
It's in Atlanta.
Okay, well, usually the court makes arrangements to have you appear in court. I don't know if they're going to do a Zoom video conference or if they're going to have you transported. That I don't know. You'll have to contact the courts. You'll be able to use the phone, and you'll have to contact the courts, or at least have someone that you know contact the courts on your behalf to figure that out. But you should be able to still have that matter heard and handled, although you're here. So you just need to make some phone calls and get someone to assist you with that, and probably talk to your probation officer as well.
That I can't do because I don't know his number by heart. So I'm just gonna want to ask you now, like, if all the probation I'm on in Fulton County, y'all just gonna go ahead and revoke all that. The charges need to be gone ahead, and I need to go ahead and be notified so I can be prepared for whatever y'all got, whatever y'all trying to do to me.
Okay, Mr. Millett. So
this is my first offense in Clayton County. So what I'm basically saying is, I know about me getting caught in Fulton County with drugs. Okay, I understand what the consequences is, but by me having this my first offense in Clayton County, I'm just trying to see like, what should we go with there?
Okay, so that sounds like a question for your attorney.
Exactly.
The attorney that I represented, that I've appointed to represent you, that attorney is going to reach out and be in contact with you. They're going to reach out to you at the jail. They'll probably come to the jail to see you. But like I mentioned, remember these 2 court dates that you have in Clayton, July 12th and July 16th. And so certainly your attorneys will talk to you before then, and then you can ask those questions as far as where do you go from here and what you need to do to help prepare a defense in your case. Okay, because I don't have the answers to that. All right, so if there's nothing further, Mr. Millett, you may be excused.
All right.
May I have your name, sir? I'm sorry, what's your name? Spell your last name for me.
M-I-Z-E.
Oh, okay. All right. First name Ernest?
Yes, ma'am.
Okay. All right, sir. So you have been charged with 1 count of battery family violence. Based on your history, that charge it was charged as a misdemeanor, but based on your history, it's being upgraded and charged as a felony. So it's going to be felony battery family violence. And at this time, I am denying bond. I'm showing that you have a 14-year probation sentence that started in September of 2016 out of Athens, Clark County. So I am not authorized to set a bond at this time. If you do ultimately get a bond, you will have some stay away, no contact conditions to that, and that is to have no contact with Tony Jenkins and to not return to 3019 St. Andrews Court in Jonesboro, Georgia. But the issue of bond will be determined and readdressed on July 16th, 2021. That is going to be your bond hearing date. The felony preliminary hearing date is going to be scheduled for July 12th, 2021, to determine whether or not there's enough probable cause to keep you detained on this charge of battery family violence. I have received your application for a court-appointed attorney. I am approving it, and I have appointed an attorney to represent you in this proceeding. Do you have any questions for me, Mr. Mize?
No, ma'am.
All right, you may be excused. Have a good day. May I have your name, sir? Speak up for me, sir.
Farrey, Marvell.
All right, Mr. Mizell, you have been charged with 1 count of possession of marijuana less than an ounce. That bond amount has been set at $1,500. Do you understand your charge and the bond amount? Do you believe you'll be able to make bond, sir? I'm sorry?
Yes, ma'am.
Okay. Your preliminary hearing date has been scheduled for July 13th, 2021, but that court date will be waived once you bond out like you believe you'll be able to do. I have reviewed your application for a court-appointed counsel, and based on your responses, I am approving your request to have an attorney appointed to represent you. Do you have any questions for me, sir?
No.
All right, you may be excused. Have a good day.
Good afternoon, ma'am.
Good afternoon. May I have your name, sir?
Frank
Say that for me one more time.
Osei.
Okay, thank you. All right, Mr. Osei, you have been charged with 1 count of theft by taking. That bond is $2,000, and 1 count of criminal trespass. That bond is $3,000. So your total bond amount is $5,000. Do you understand your charges and your bond amount?
No, ma'am.
Okay, so do you want me to read the facts of the warrantless arrest affidavit that led to these charges being brought against you?
The charges that you just mentioned, when police was about to get me off where they came for me, I asked him what was my charges for arresting me. He said theft by taking. You said that. And you mentioned another one, which is 2 charges right now.
It is. So let me, and that's the purpose of this proceeding. Okay, that's exactly why we have first appearance. So that way people who are arrested can understand and know the actual charges that are brought against them. So that is why I asked you whether you understood. And since you mentioned that you did not understand, you only know about 1 charge, let me read to you the facts that led to both charges being brought against you, okay? So it states that on May 28th of 2021 at 1296 King Road in Riverdale, Georgia, at approximately 10:09 a.m., that the defendant did commit the violations of Georgia law, which include theft by taking and criminal trespass, and that said offender did unlawfully took a piece of mail out of the victim's mailbox. Mr. Emo Noam and opened said mail. Said offender placed said mail into his vehicle, a 2008 gold Honda CRV, tag CQK6074. Said offender did commit the offense of criminal trespass when he knowingly and without authority entered upon the land of 1296 King Road. Said offender advised that he opened a back door that was already ajar and entered the residence to see if it was vacant. Said victim, Miss Shirley Noam, is the homeowner. Victim number one, Mr. Emo Noam, is the owner of the mail that was removed and opened out the mailbox. Victim number two, Miss Shirley Noam, is the homeowner of the residence, and she advised she wanted to press charges. Said incident took place in Clayton County. So based on that, Mr. Osei, you were charged with theft by taking and criminal trespass. So the total bond is $5,000. Do you believe you'll be able to make bond?
No, I won't be able to make bond. But Your Honor, I have a question here.
Okay, hold on, because I want to make sure I give you some additional information that is important for you to know. And then at the end of this, I'll ask you what questions you have for me. Fair enough?
Could you please let me ask my question before you continue?
All right, so Mr. Osei, I'm just going to mute you right now, okay? As a condition to your bond, you are to stay away and have no contact, directly or indirectly, with Ms. Shirley Noam. Also, you are not to return to the location that was listed on the warrantless arrest affidavit. That's the 1296 King Road in Riverdale, Georgia, 30296. Also, I have scheduled a preliminary hearing date for you. That court date is July 13th, 2021 at 8:30 a.m. That preliminary hearing date will be waived and you'll receive a new court notice in the mail in the event that you aren't able to bond out. You indicated that you're not going to be able to bond out. So if you are still incarcerated, then you will be brought before the court on July 13th, 2021 for the court to determine whether or not there's enough probable cause to keep you incarcerated based on these charges. I have received your application for a court-appointed attorney. And based on your responses, I have approved an attorney to represent you. So that attorney will reach out to you and will be in contact with you to help you discuss your case and any defense that you may have. Okay, so now, Mr. Osei, I'm going to ask the officer to unmute your screen. And then if you have any questions about what I just mentioned to you, which is your bond amount, your preliminary hearing date, the fact that I've appointed an attorney to represent you, and your charge, I'll listen to your question at that time. But this is not a trial, so keep that in mind. What question do you have, sir?
Yeah, one thing I know is according to my name written in the capital letters, is representing as a bond itself to the state and the system. And then cash that you mentioned is also a separate thing that represents as a bond. So here you are talking about two bonds. My name as a bond representing the state and the system, and the cash bond mentioning right now is it's two things right now. As so can you make it clear for me to choose one? Just like using my name as a bond to Clayton County. The last time Clayton County arrested me, the same issue happened. They used my name as a bond and told me not to worry about my payment, $700.
Okay.
So
I think I understand what you're saying. So what it sounds like is you may be asking whether you can have an OR bond or a signature bond where you just sign your name and you don't make a payment and you're released from jail. Is that what you're asking? Whether that's an option?
Yes, that was what
Okay.
we did the other time. And now
Okay.
what date is on the first day.
I understand, Mr. Osei. I understand your question now. So the response to that is no. I am not authorized, based on Chief Judge Keisha Wright Hill's directives, I am not authorized to give you a signature bond where you sign your name and you're released. So you will have to pay the bond of $5,000 through a cash bond or through a commercial bonding company or using a property bond. Okay, do you have any other question for me?
Okay, thank you.
You're welcome. Have a good day. May I have your name, sir?
Hassan.
What's your last name?
Hassan, Hassan.
Your Honor, they have it here as Hassan, P-A-S-A-N.
Oh, I see. Okay. All right. So, Mr. Hassan, you have been charged with 1 count of DUI alcohol less safe. That bond is $6,000. Failure to yield while turning left. That bond is $500. And no insurance. That bond is $1,000. So your total bond amount is $7,500. Do you understand your charges and your bond amount?
Yeah.
Do you believe you'll be able to make bond?
Yeah.
All right, your preliminary hearing date is currently scheduled for July 13th, 2021, but that court date will be waived once you bond out like you believe you'll be able to do. I've reviewed your application for a court-appointed attorney, and I am approving your request to have an attorney represent you. Do you have any questions for me, Mr. Hassan? I'm sorry?
No, ma'am.
Okay, you may be excused. Have a good day. Good afternoon. May I have your name? Last name Price, you mentioned?
Yes, ma'am.
Okay. Mr. Price, you have been charged with 1 count of possession of marijuana over an ounce, 1 count of violation of the Georgia Controlled Substances Act, Schedule 3 drug, as well as 1 count of drug-related objects, use or possession of drug-related objects. Your total bond between all 3 charges is $10,500. Do you understand your charges and your bond amount?
Yes, ma'am.
Do you believe you'll be able to make bond, sir?
Yes, ma'am.
Your preliminary hearing date is being scheduled for July 12th, 2021 at 8:30 a.m. But if you do bond out, then that court date will be waived and you'll receive a new notice in the mail. I have reviewed your application for a court-appointed attorney, but I'm not able to read your handwriting where it states how much your gross monthly income is. So how much do you believe you make per month?
I make $2,300 a month.
You said 2,300?
Yes, ma'am.
Okay, so I am approving you to have a court-appointed attorney. So he or she will be in contact in regards to representation in your case. Do you have any questions for me, Mr. Price?
You said that 10,500, right?
Yes, 10,500 total.
Thank you.
All right, you're welcome. Have a good one. May I have your name, please?
Reynolds, ma'am.
You said Azil Reynolds?
Yes, ma'am.
Okay. So, Mr. Reynolds, you've been charged with 1 count of simple battery. That bond is $5,000. Do you understand the charge and the bond amount?
Yes, ma'am. I have a question once you finish, ma'am.
Thank you. There is a condition to this bond, and that is to stay away, absolutely directly or indirectly, and have no contact with Quanzio Reynolds. I know that is your live-in brother, at least that's what was indicated on the warrant, but you are to have no contact with him at this time, and you cannot return to 6726 Terra Boulevard. I believe that's apartment 11I in Jonesboro, Georgia. Do you understand that bond condition?
Yes, ma'am. But also, my brother lives in Chicago. Doesn't live in Georgia.
Hold on, let me review the warrant again and see what was stated. I thought it was indicated that he resides there. One moment. So the warrant, Mr. Reynolds, does state the offender referring to you is the live-in brother of the victim. So that is what has been indicated on the warrant. Now, I will say this, the goal here is to have no contact with Mr. Reynolds. And so because they had indicated that you all were residing together, that is why I also added the condition about not returning to the premises. So if, I'm gonna leave that condition on here just because, again, I don't have any other information other than what you're saying and what's stated on the warrant. So I'm not inclined to get rid of that condition at this time. What I will do is I'll allow you to go back to the residence to retrieve any personal property that's undisputed. Now, if you have proof or something like that, that your brother doesn't live there anymore, I would advise that you reach out to your counsel or the prosecutors to make them aware of that. And sometimes what'll happen is the prosecutor will agree to modify the bond condition about that location. I'm reviewing your application for a court-appointed attorney. And based on your responses, I will appoint an attorney to represent you. And like I mentioned, if you bond out, the court date that I've set for July 13th, 2021 will be waived and you'll receive a new court notice in the mail. Do you believe you'll be able to make bond, sir? Okay. Do you have any other questions for me?
No, ma'am, you answered my question that I had earlier.
Okay. Well, have a good day, Mr. Reynolds. Thank you. Thank you. Good afternoon. May I have your name, sir?
Goldwyn Redding.
You said Goldwyn Redding?
Yes, ma'am.
All right, Mr. Redding, your hearing is what is called an extradition hearing. All of the rights that I mentioned to everyone earlier also apply to you in this particular hearing. But your hearing is a little bit different from the other first appearance hearings that have just taken place. You don't have any charges pending against you here in Clayton County. You have been brought to court today because you have charges pending against you in another state, and they're requesting that you return to answer to those charges. Do you have an attorney representing you in this particular matter, Mr. Redding?
Currently, I do this now.
You say you do?
Yes.
Who is your attorney representing you?
Stacy Jackson.
You said Stacy Jackson?
Yes, ma'am.
Okay, I'm just gonna indicate that. All right, now this hearing is being conducted pursuant to OCGA Title 17, Chapter 13, as it is alleged that you are being charged with knowingly and willingly entering and remaining in the state of Georgia, knowing that you are wanted out of Virginia. It looks like it's Henrico County Sheriff's Office for strangulation of another causing injury. That warrant number is 2020-0822-619. It is a felony, and they have indicated that they will extradite. So you have a choice as to whether you wish to contest extradition or to waive extradition and be returned to the other state of Virginia without going through the formal extradition process. Now, if you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the other state. The court may consider allowing you to post a bond, but the court is not required to do so. And as you are wanted by the state of Virginia, I am not setting a bond in your case at this time. If you do not wish to voluntarily return to the state of Virginia, you may file what is called a writ of habeas corpus to contest the extradition. And the writ of habeas corpus can only contest 4 things. 1, whether the extradition documents are in order on their face. 2, whether you are charged with a crime that actually exists in the demanding state of Virginia. 3, whether you are the person named in the request for extradition. 4, whether you are in fact a fugitive from justice. You are entitled to the advice of counsel when determining whether to contest extradition or deciding whether to waive extradition. Now, you cannot contest your guilt or innocence in this state with regards to the charges in Virginia. If Virginia is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days while awaiting your extradition. If extradition is not completed in 90 days, then you will be released. So do you wish to contest extradition or waive formal extradition and voluntarily return to Virginia to answer to the charges against you?
Waive, Your Honor.
Okay, so what you'll need to do, Mr. Redding, is you'll receive several copies of the waiver form to waive extradition. You'll be given, essentially, once you sign it, it'll be sent to me, and then I will sign it today and send it back, and they will begin processing your extradition back to Virginia. Do you have any questions for me, sir?
Just one. Being that I'm gainfully employed, how long will said extradition take place? How long will it take?
So that is up to Virginia to decide. That information I don't know. They have to make those arrangements. It did indicate on the warrant that they've mentioned that they will extradite you. So it sounds like that, you know, they've been in contact and maybe they've started that process. But as I mentioned earlier, if extradition isn't completed in 90 days, then you'll be released.
Okay, thank you.
All right, you're welcome. Have a good day. May I have your name, sir?
Colorado.
So, Mr. Rousey, you have been charged with 1 count of aggravated assault with a deadly weapon. Your bond is set at $25,000. Do you understand the charge in your bond?
Yes.
You do have a condition to that bond, and that is to stay away and have no contact with Jonathan Lee and to not return to 7436 Fielder Road in Jonesboro, Georgia, 30236. It appears that that may be a shared residence. And so if it is, I have stated on here that you may schedule an appointment with the sheriff's office to accompany you to go back to retrieve any undisputed personal property from that residence. And that must be done within 10 days of being released. Do you understand those conditions? Do you believe you'll be able to make bond, sir?
Yes, ma'am.
I have scheduled your preliminary hearing date to take place July 12th, 2021 at 8:30 a.m. If you are bonded out by that date, that court date will be waived and you will receive a new court notice in the mail with your new court date. Are you requesting to be considered for a court-appointed attorney, sir?
Yes, ma'am.
Based on your responses, Mr. Rousey, you don't qualify for a court-appointed attorney, so you will be responsible for hiring your own counsel to represent you. Do you have any questions for me, Mr. Rousey? Do you have any questions for me, Mr. Rousey? Okay, all right, you may be excused. Good afternoon. May I have your name, please? Johanna Sabatu? Okay. So, Mr. Sabatu, this hearing for you is what is called an extradition hearing. All of the rights that I've mentioned earlier and advised everyone of also applies to you, but your case is a little different. And what I want to let you know are the rights that you have based on what you've been charged with, which is a fugitive from justice. You don't have charges pending against you before me here in Clayton County. You have been brought to court today because you have charges pending against you in the state of South Carolina, and they are requesting that you return to South Carolina to answer to those charges. Do you have an attorney representing you in this matter?
My family is hiring one at the moment.
Okay. Well, like I mentioned, you are charged with being a fugitive from justice. The warrantless arrest affidavit states that you entered and remained in the state of Georgia knowing that you are wanted by H&E Control, Narcotics and Drug Control Division in Columbia, South Carolina for dangerous drugs possession, which is a felony. And that warrant number in South Carolina is 2020-060374. So this hearing is being conducted pursuant to OCGA Title 17, Chapter 13. And as you have heard, it is alleged that you were charged with a fugitive from justice from the state of South Carolina. You have a choice as to whether you wish to contest extradition or to waive extradition and be returned to South Carolina without going through the formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. And during that time, a warrant will be prepared under the state of Georgia's governor's signature for your extradition to South Carolina. Now, the court may consider allowing you to post a bond, but the court is not required to allow bond in your case. And because you're wanted by the state of South Carolina, I am not setting a bond in your case at this time. If you do not wish to voluntarily return to the state of South Carolina, you may file what is called a writ of habeas corpus to contest extradition. The writ of habeas corpus can only contest 4 things. 1, whether the extradition documents are in order on their face. 2, whether you are charged with a crime that actually exists in the demanding state of South Carolina. 3, whether you are the person named in the request for extradition. 4, whether you are in fact a fugitive from justice. Now, you cannot contest the issue of guilt or innocence in this state. So you are entitled to have the advice of an attorney when determining whether or not you want to contest extradition or waive extradition. Now, if the state of South Carolina is unable to extradite you within 30 days, you may be committed to the Clayton County Jail for an additional 60 days while waiting your extradition. And if extradition isn't completed in 90 days, then you will be released. So do you wish to contest extradition or waive formal extradition and voluntarily return to the state of South Carolina to answer to the charges against you?
I'd like to answer to the charges against me.
I'm sorry, say that again.
I'd like to answer to the charges against me.
Okay, so I'm going to indicate on here that you are waiving the formal extradition hearing, so that way you can voluntarily return to South Carolina to answer to the charges against you. What you're going to receive is several copies of a waiver form from the jail. So I want you to sign the copies of that waiver form. Once you sign it, I am also going to sign it as well, so that way we can start the extradition process as soon as possible. Do you have any questions for me, Mr. Sabatu?
No, I don't.
Okay, well, you may be excused. Have a good day.
Sure.
Thank you. May I have your name?
Giovanni Serrano. Giovanni.
Thank you. So, Mr. Serrano, you were charged with 1 count of speeding, exceeding the speed limit. I've reviewed the warrantless arrest affidavit and it lacks probable cause, so I have dismissed your case. So once I sign the dismissal, you'll be free to go, sir. All right. All right. Have a good day.
Thank you.
May I have your name?
Wilson Williams.
All right, Mr. Russell Williams, you have been charged with 1 count of aggravated assault by strangulation, 1 count of theft by taking, 1 count of battery family violence. You do have a bond on the battery family violence. That bond is $6,000 with the condition to stay away from Denisha Everson and not return to 5930 Highway 85, apartment 306 in Riverdale, Georgia. Your bond for the theft by taking is $2,000. The charge of aggravated assault by strangulation, I am denying bond based on that charge at this time. Do you understand what I've mentioned as far as your charges and your bond? I have scheduled a preliminary hearing date for you. That is July 12th, 2021. I have also scheduled a bond hearing date for you, and that bond hearing date will be July 16th, 2021. Do you plan to hire your own attorney, or would you like to be considered for a court-appointed attorney?
I have an attorney.
Okay, who is your attorney?
I just know his first name is Mr. Robert.
That's the first name?
Yes, ma'am.
You don't know the last name?
No, ma'am.
Okay. All right, I'm just gonna indicate on here that you're hiring your own attorney. Do you have any questions for me, sir?
No, ma'am.
All right, you may be excused. Have a good day. Tell me your name again.
Robert Willis.
Okay. All right, Mr. Willis, you've been charged with no license and given a false name. Your total bond between both charges is $2,000. Do you understand your charge and your bond amount?
Yes, ma'am.
Do you believe you'll be able to make bond?
Yes, ma'am.
Your preliminary hearing date is scheduled for July 13th, 2021. But once you bond out, like you believe you'll be able to do so, that court date will be waived and you'll receive a new notice in the mail. Do you plan to hire your own attorney, or do you want to be considered for a court-appointed attorney?
I will be hiring my own.
Okay, so I'm going to indicate on here that you plan to hire your own attorney. Do you have any questions for me?
Not at all, ma'am.
Okay, well, have a good day. You can be excused. Thank you. May I have your name? You said Terrell Wilson? Okay. Deputies, is Mr. Wilson the last inmate?
Yes, ma'am, he is.
Okay. Stand by for me, Mr. Wilson. I need to look a few things up in your case. So give me a few minutes. It's probably going to take about 5 or 10 minutes, okay? So give me one moment and I'll be back. All right, I am ready for Mr. Terrell Wilson now. If you can unmute, Deputy, thank you. Okay, all right, Mr. Wilson, so you have been charged with several offenses. You have one count of violation of the Georgia Controlled Substances Act, Schedule 1 possession, one count of driving under the influence, one count of failure to maintain lane, one count of DUI child endangerment, one count of violation of child restraint, one count of seatbelt violation, one count of drug-related objects or being in possession of a drug-related object, and also a count of crossing the guard line with drugs. All of those offenses have a total bond amount of $19,500. Do you understand the charges and the bond amount?
19.5.
Yes, $19,500.
Yes, ma'am.
Do you believe you'll be able to make bond?
Yes, ma'am.
I have scheduled a preliminary hearing date for July 12th, 2021 at 8:30 a.m. If you bond out, that court date will be waived and you'll receive a new notice in the mail. Do you plan to hire your own attorney or do you want to be considered for a court-appointed attorney?
I would like to be considered for one, but I do plan on hiring one.
Okay, so in reviewing your application, I am approving you for a court-appointed attorney. You do qualify. So I am appointing one to represent you. And if you do hire your own attorney, sir, like you plan to do, just make sure you notify the court and notify the court-appointed attorney that you have private counsel. Do you have any questions for me, Mr. Wilson?
No, ma'am. 19.5. Yeah. No, ma'am.
Okay, yes, $19,500. All right. Have a